Yes. Good morning, everybody. Good morning, friends. Good morning, Swanand. Good morning, Pooja ma'am. Swapnil.
Yes, sir. Good morning to all of you.
Good morning. On behalf of Appasai Gurnani College of Architecture, I welcome Swapnil Kulkarni and Pooja Menon ma'am. Today's topic is intellectual property rights. Good morning, Sanand. I request Swapnil Kulkarni to kindly introduce our speaker and proceed further with the proceedings. Thank you.
Thank you, sir. So now I'm requesting Pooja ma'am to turn on her video so that I can introduce him. Ma'am?
My video is on.
Yeah, sure, I got it. So I now kindly introduce you that Pooja Menon is one of our experts with working with us, Magic Prints, and she is very she is working in this field since 7.5 years. So the huge support to our company from the Pooja ma'am. So I now request hand over all to her and now I request her to start the session.
Thank you, Swapnil. I'll be just sharing my screen for the presentation.
Yeah.
Hello, good morning, everyone. My name is Pooja Menon, and today we'll be discussing regarding intellectual property right. I'm thankful to your institute and Swapnil, who is one of our business partners. He has been working with us for the past few years, and it's a privilege that even during this time, the educational institutes are not restricting themselves from innovations, from discussing about patents, and a college like you have huge potential when we're talking about architecture. So let's proceed with today's session. Before we begin, I'll just like to brief about what our company does. We have been collaborating and providing seminars, educating institutes, industries regarding patent. We have addressed more than 32,000 students in past 2 to 3 years. And we have filed more than 500 patents in the past 3 years. And we are looking forward to keep this culture with the lowest cost in India. Okay, so here on your screen, you can see a question which states that all I asked was, can I patent my copyrighted trademark? If looking at this question, if you do not find any confusion, या आपको कोई query नहीं हो रही है कि अच्छा इसमें क्या लिखा है, then this session is very much important to you. Basically, there are two types of property. दो type की property होती है. One is called the physical property, other is called the intellectual property. Physical property, you all know, like your land, house, money, gold, these are called your physical property. Now, we are very protective about our physical property because we think that to make physical property, we need to earn a lot of money, we have to do a lot of hard work, and we are very protective about it. So if you buy a beautiful house, you'll first register it with your with the government, government, so that you can claim your ownership. सो इवन इफ अगर मैं कल आपके घर कॉफी पीने आती हूँ और मैं ऐसा कहती हूँ कि मुझे आपका घर बहुत अच्छा लगता है एंड आज से मैं ये घर पे रहना चाहती हूँ, आप सब अपना बोरिया बिस्तरा पैक करो और घर से चलते बनो, कैन आई डू दैट? Actually, no, because you have the property papers which claim that the house is yours, right? So you can anytime claim about your your physical property, even if it's your house, your car, or anything which has a government registration proof. Talking about intellectual properties, it secures your ideas and innovations. Now, in today's world, suppose you are involved in in the field of research. Now an idea clicks. What is the first thing as a human you'll do? It is a basic mentality that we would love to share our ideas, our innovations, or whatever thought we have with either our colleague or maybe a friend of ours, just to be sure that the idea is innovative or it is out of the box or it is brilliant. Now the mistake we make is that we trust that person with our idea. We know that our idea had a potential and we decided to to share it with the person without securing it. Now there is a big possibility that he or she might use the same concept for their own benefit without providing you with any credibility. Now what do you do at such circumstances? The only thing usually we do is maybe go out and scream on that person, or we can take no action about it. But what did government do is as you secure your physical property, similarly to just safeguard your intellectual property, they have provided a benefit called intellectual property rights. It is categorized into 4 parts: patent, copyright, trademark, and design. So whatever you do in your field, it can be protected one by one in different categories. So today in our session, we'll be understanding all the work that we do, whether it is included under patent, copyright, trademark, or design. And we as an individual, how can we fulfill it? So the first topic we'll be discussing is copyrights. Copyrights is very simple and it's a very good concept. It secures the right of an artist, an author, a creator. Okay, so what does that mean? We all may not be involved in maybe education. We are not all academicians maybe, but we all love to draw, paint, and you being students or faculties from the sector of architecture, you're very well into the field of drawing, painting, photography, and building things that are beautiful, right? So all those things like softwares, books, photography, movies, paintings, sculptures, drawings, all are included under copyright. Now, people usually ask me that in case like I have done some creative work, why should I file a copyright for it? I can simply, publish the work and claim that the work is mine. So why do I need to file a copyright for it? Now let's take an example to understand better. Suppose I decided to do a painting maybe, and I published it online. Now, once I have published it, it is not just your family members or maybe your friends who are able to see your work. There are multiple people, multiple big companies who actually has the right to access public data. Now, what happens? Suppose you published your work and a good company loved your, suppose you did some architectural work and you published it, and a company who's involved in making buildings loved your work and they used your concept to build their building. Now, what do you do at such circumstances? They are not your friends or colleagues that you can go and say, look, that was published on my website first, and you cannot use it for your benefit. Only document which can help you in such circumstance is a copyrighted document? Let's take an example to understand. See, here in the image, you can see on the right hand side, Obama sir's photograph was clicked by a press media agency. It was beautifully modified for their newspapers and newsletters, which can be seen on the on the right hand side. Right now, once the photo was modified, it was published in their newspapers, magazines for their own benefit, and to advertise during the elections, which was being campaigned at the time of Obama sir. Now, what happened was, advertising agency was given a task to, print more banners and posters to propagate to vote for Obama, sir. So what he did was, he took this image, he wrote the title "Hope" under it, and published this banner and poster all over USA. The press media agency came to know about it. So what he did was, because the campaign was done by the council members of Obama sir, walked into their office and he was like, "Sir, I'm from the press and I have some questions for you, and I need some favors too." Because it was election time, everybody required huge media attention. So what they did was, a person came out to attend this media person, and he was like, "Yes, sir, please tell me, how can I help you?" He was like, "Sir, the new banners which are available all over USA, I want to talk about that." So the guy was very impressed. He was like, "Oh my God, so the banner is catching on attention." He was like, "Yeah, the banner which you have put on is the work created by my agency. Now, as you have used it without our permission and giving us no credit, I'll request you to remove it." The council members of Obama sir started laughing. They were like, "Pee kya hai ho gaya? Are you drunk in the morning? Do you know what you're asking us for?" He was like, "Fine. You do not want to listen to me. It's quite okay. I'm going to the media and I'm going to shout that the person who wants to be the president of USA does not even follow copyrights. Now, if tomorrow he's elected and he becomes the president of USA, what if he takes away all our rights and he gives us nothing?" See, copyrights may not be a very big agenda, but during an election, picking a fight with a press media agency is very dangerous. It provides opposition with a bigger weapon to fight with. So, another member came out and he was like, "Sir, I heard your discussion and I understand what problem you're facing right now because we do not give you any credibility. We cannot remove the banners. As you know, it's kind of our prestige issue. But we know your media. You are going to shout and scream about what we did. But till the election, we'll ask you to keep your mouth shut and tell us how much do you want us to pay. हम आपको कितना पैसे दें जिससे आप अपना मुंह बंद रखेंगे इलेक्शंस तक. Very simple. The guys were paid in huge amount, which was never disclosed. But till election, this news was not even out. So that is the power of copyright. So if you own a copyright, you can actually stop big agencies, big companies, or powerful men from misusing your work. Okay. So here is one of the very good examples. We all know about the Eiffel Tower in Paris, right? It's a beautiful construction. Now, the world renowned construction was built in far 1889. A copyright is, the rights of the copyright can be with a person 60 years after the death of the creator. So it is actually a lifetime for the creator, and after 60 years of his death, still the person can be provided with the royalty. That is why Michael Jackson is a legend whose kids and all the people after him are still enjoying the royalty of $90 million per year from the work he has already created. Okay, so that is an example of how much potential a copyrighted work has. Now, the architectural work like Eiffel Tower, the rights to click photograph of the artistic work, the artistic tower, has expired. But this view, which you can see in the presentation, which is a photograph of 2 a.m. at night, which is a fully lit Eiffel Tower, the rights of the photograph, which is clicked at 2 a.m., is still with a French company. So even if you want to go and click a photo in front of Eiffel Tower, you can do that. Use it for your own maybe profile pics or something, that is okay. But if this photograph is anyway used by you for a commercial purpose, maybe a banner, maybe a advertisement, this company will come and claim against you. So you can actually go visit the place, click photograph for your personal benefit, but of a normal Eiffel Tower, it is okay. But this fully lit 2 a.m. photograph cannot be used for any commercial purpose because it is still an active copyright, and nobody else can use this photograph for any commercial benefit. So now you understand. So if you are creating an architecture and you want to protect it, then you can have a copyright of it, of the images, and even trademark of the images, which we'll be learning ahead, and you can actually safeguard that nobody else can use it. The very good example is the Empire State Building. Because you're architectural people, you will be knowing about the Empire State Building, which is a beautiful building in New York. It has a huge history. The rights of the building, the images, are still with the company who created the structure, and nobody can use it for the commercial purpose. That means you click the picture of the building with something and you want to advertise it, you will actually have to take permission from the creator of the building. So you people who are designing architectural work can have copyrights on it. See, when you design a blueprint for a building or maybe an interior design structure, you need to have copyright so that before you portray it in front of your clients, they don't copy it. ओके सो ये बात आपको ध्यान रखना बहुत जरूरी है कि जब भी आप कोई भी स्ट्रक्चर डिजाइन करते हैं ऑन पेपर, या फिर आप उसका ब्लूप्रिंट डिजाइन करते हैं, या इंटीरियर स्ट्रक्चर का आप एक रफ डायग्राम ही क्यों ना करें, किसी को प्रेजेंट करने से पहले प्लीज उस पर कॉपीराइट ले लें, जो एक ऑनलाइन प्रोसीजर है विच टेक्स ओनली 5 minutes टू फाइल. 5 minutes, take rights on it and then showcase it to anybody. Because see, जब हम artistic work की बात करते हैं, the people you're presenting it to has equal or maybe a more capability than you. Even by looking at your image, they'll get the idea. Copyright secures the presentation of something. See, you cannot have rights on the entire Eiffel Tower, but it is the photograph, the presentation, and the look and feel which your work provides that is secured using copyrights. Copyright आपके presentation को secure करता है. That is why every book you read, every images you see, every design you look at is copyright protected so that nobody else can use your work for any other purpose. Okay. Now, the consequence of infringement. See, here we are talking about the software. There are multiple infringement cases of copyrights. This is about the software which was developed by a US-based company. And see, one benefit before I discuss, copyright is worldwide protected. If you file a copyright in India, nobody in the entire world can use your work. So that is the most biggest benefit of copyright filing. So copyright gives you an international protection because it is an artistic work. Okay, and it has the highest lifetime security. That is, only copyright has that. Otherwise, all other IPR has a limited period. Copyright has the longest one. Okay, so talking about infringement, Epic Systems is a company that develops software for US-based clients. Okay, they had a software made for hospital chains in USA, and that work was being maintained by an Indian company, that is TCS. TCS was providing maintenance work to the hospitals for this software. Now, it is a basic rule and it is followed by every company that whenever a third-party software is being maintained by another company, you are required to sign a confidentiality agreement that you won't copy any content, use it, misuse it for your own benefit. Now, what happened was the employee who was working for TCS loved the software. He came back to India, pitched the idea to some of his colleagues here. They developed a software called MedMantra for the hospital chains in India, and Epic System came and caught them. Epic System slashed TCS with a damage fees of $940 million. See, the contract was signed by the employees, maybe the lead, the team leaders of the company. The work was done by the employees. The software was developed by the employees. It was pitched by the marketing team. But at the end, because of the infringement, the person who had to pay is the company itself. So if you are an employee or maybe working as an own company, or you decide to be an entrepreneur tomorrow, please do not copy the work. If you decide to do that, you will have to bear the the consequence of infringement. So please be careful when you're working on it. Okay, so moving ahead, the next topic we'll be discussing is trademark. So copyright secures the artistic work, the drawings, the painting, the structures that you design, the placements, everything that you have a creativity on, a perspective which is not logical. There is no math in it. If you decide to make a building like a pyramid, it is a design, it is your creativity, there is no logic to it. So if there is something that is creative, can be secured under copyrights. Talking about trademark, it protects a brand's identity. That is, suppose I want to identify a building, or maybe identify a product or a food chain. Usually I use its name, its logo, symbols, taglines, jingles, which provide a brand with an identity. Like, I'm driving on the road with a capital and I see a capital yellow M on the roadside, so I'll immediately recognize that it is McDonald's. I don't even have to think about it, right? Yellow M means McDonald's, and McDonald's has a trademark on the symbol yellow M for food chains. Okay, so trademark provides the brand with that protection that nobody apart from the company can use the brand name or the symbol for any other purpose. That is why you will see a small TM or R symbol near the logo or the brand name. That means it is trademark protected. Okay, similarly, talking about logos, there are a lot of jingles and taglines, like the company has, Sprite has the line "Sab clear hai," right? So that line is trademark protected so that nobody else can use it for the advertisement purposes or to portray their product using the same line. So every tagline, every jingles, every logo that you see is trademark protected, which gives the product with an identity. Okay, there are a few more things that are protected under trademark, that is sound, smell, dialogue, voice, three-dimensional design. Now, why these things are protected? Let's take example and understand better. हम जब smell की बात करते हैं, talking about smell, whenever you decide to buy a perfume or maybe a deodorant, you do not just check the brand name, right? It is not just the brand name that is important. You will definitely check how good this perfume smells on you, right? Obviously, because the brand name does not matter if you smell good. Okay, so every perfume manufacturing company, whenever they decide to buy, manufacture or produce a new banner, or maybe a new perfume or deodorant, they will trademark the smell so that no other company can manufacture a perfume with a similar smell, so that they do not stand as a competitor in the market. Talking about sound or voice, when we were kids, right, we used to watch Tom and Jerry, and there is a sound of a lion roaring in the beginning of the session. Even today, if that sound is played, we all get nostalgic about that sound, and we'll first think about Tom and Jerry. It is a registered trademark sound of Walt Disney. That is why whenever you see that line, there is a symbol of TM besides it. That means it's a trademarked sound, and nobody except Walt Disney can give anybody the permission to use that sound with the lion on the screen. Okay. Every cartoon character that you see is trademark registered. That is why whenever you decide to buy a cartoon printed t-shirts, bottles, or bed sheets, they are much more costlier than the regular bed sheets and t-shirts. See, the people who decide to create such characters, they provide an identity to a character, a cartoon. So it is trademark protected. Now, see, whenever a sketch is made, a drawing is made, it is first copyright protected before it has launched into the market. Once it is portrayed in front of the market, when audience has seen it, now it is an identity. Now, if I talk about Chota Bheem, I know which character people are talking about. First, when it is just scripted, it's just a story. I don't know. But when a character is sketched, it becomes an identity. It becomes trademark. So every symbol, every person character that is created is trademark protected. And the person who has created those character gets a royalty whenever the character is printed on toys and toys, t-shirts or clothing or food products. It is called the character merchandising law. So we actually are not just paying the manufacturing cost, but along with that, we are paying them with the royalty amount to the person who has created the logo. Okay, so even if you are artist and are creating multiple designs or logos or symbols or even cartoon characters as for advertisements, you should trademark it, or you should at least ask the client whom you're providing to have a trademark on it. Okay. This is one of the famous Indian trademarks. We all know what this is. We would have seen the building, and you being people from Maharashtra will know what place is. This is the Taj Mahal Hotel Palace, and that is the hotel which you all have seen in Maharashtra. The architectural structure, the tower wing exterior, it is a registered trademark because this see, it is an architectural design. We understand it would have been a sketch. When it would have been a sketch, it would have been copyrighted. But once it is the symbol, like when you go down to Mumbai, people will ask you to go and visit Taj Mahal, right? They'll ask you to visit the Taj Hotel, and it became a public attention. It became a a symbol of what do you call it? It became a trademark, and then it was applied, the image was applied for a trademark, which is a recognition of the place. So nobody else can create a similar structure or use this photograph for any other public business without their permission. So even if you have created an architectural structure and you think maybe today or maybe in the future, and you want that structure to be secured as your symbol, your identity, and nobody else can use the photographs or maybe the place without your permission, you need to apply for copyrights and trademarks parallelly. Okay. These are few more Indian trademarks, that is Kapil Sharma's dialogue, Babaji Ka Tullu. Then Amitabh Bachchan ji's voice cannot be used on a commercial platform without his permission. The advertisement with his voice, so that is also trademark protected. Sunny Deol's voice. Some celebrities, politicians, cricketers have been provided with the rights to secure their own name, like Sachin Tendulkar, SRK, Namo. They have trademarked their own name. Just think, can I trademark my name? What is my difference between me and them? Okay, they are a brand in themselves. That is, if today Sachin comes on the TV and asks you to buy a water purifier, people will be mad just to go and get that water purifier, because Sachin has been drinking from that water purifier. That is what the impression the advertisement tries to create. It tries to build a trust using a celebrity's name. Now, the same water purifier, if I bring down to your home and tell you that please buy this water purifier, I will moreover look like a saleswoman because I'm not famous for now. Okay, so until and unless you are not a celebrity, you cannot trademark your own name. But what can you trademark as an individual? If you decide to have your own construction services, if you decide to build your own website, you decide to build your own products, if you decide to have your own website, all those things can be trademark protected. The name of the company which you decide, the name of the construction services you decide can be trademarked. And for trademark filing, the only detail required is your name, address, email ID, and phone number. You do not need a complete company to be established and then file a trademark. Government instructs that if you have a brand name today and you want to secure it for the next 10 years, because you're not thinking to start a business today, but in coming few years, then you can file a trademark today, and after 10 years, during the time of renewal, show us have you started using the name in any form or the other. So that is how the trademark provides you with the security. Okay. Illegal trademark, this is just for your information. If you decide to provide any of your product with a name, do not try to copy some competitor's name or create a replica, because government will check phonetically, the pronunciation, and using the spelling. So if there is any glitch in the spelling, it will check phonetically. If the pronunciation is the same, and if it is, it will get caught. Like you cannot start a company called MacDuck, which portrays or somewhere look like McDonald's. Okay, you cannot start a company called Buckstar, which looks like Starbucks. No, all these things are wrong. So please do not try to replicate or create a false name of your company which looks or it sounds similar to a famous company's name. It will get caught and it won't be registered or approved, and you will face a lot of legal consequences in future. Okay. So trademark provides valuation to your company. Just the sole name Google has a valuation of $44.3 billion. Just the name. If you want to purchase the name, you will have to pay that company $44.3 billion. Okay. So moving on to the next topic, I hope copyright and trademark are clear. If you have any questions, please drop it in the chat box. Like me and the expert Swapnil will be addressing each and every questions you have at the end of the session. And like we'll be providing you with our contact details also. So if you have any problem, you can directly give us a call and talk with us personally. Okay. So copyright is clear. It secures your creative work. Trademark secures your brand identity. Now talking about patents, it secures ideas, innovations, method, design. All these things are secured under patent. The definition of patent is very nice. It states that the government provides a exclusive right for a limited period of time to the person who provides entire public disclosure of the invention. That means for the details you have disclosed that this is what my patent is about, government will provide you with a limited period exclusive rights. The patent rights are for 20 years only. Like copyrights for 60 years after the death of the author. Similarly, patent is only for 20 years. And after that, it gets public. Okay. So patent has been categorized into 3 categories: utility, design, and plants. Plants is not for us. It means genomically engineered, where the hybridization takes place. For us, the 2 important factors are utility and design. So let's understand the difference between both. First, if you have, for example, here I have a glass. Okay. Now, there are multiple companies which is manufacturing glasses. So every company who decides to make glass can have a design patent because the utilization is the same. If I want to drink a beverage, I will be using a glass to drink from it, right? To store it, to hold it. So there is no difference in the working of the glass. But now I decide to make a glass which has a self-steering mechanism. That means I'll pour in milk, sugar, and coffee powder, and the glass will self-steer it to make me a cup of coffee. So now the glass has a characteristics. So it will fall under utility patent. So very simple. If I have a method, a mechanism, a working of an instrument, then I will bifurcate it into utility patent. But I am only changing the structure of something, then I will file it under design patent. Okay. For example, now stairs. In a building you have stairs. The utilization is the same. You want to climb somewhere, you want to get down from somewhere, the stair will stay the same. So if it is a stagnant stair, you can, and you have designed it beautifully, like you have made it in a with a curls or something like that, a curly stair or something, you can apply for a design patent. But if you decide to provide it with a mechanism like the escalators, like which you see in the malls, right? They are moving stairs. That means it has been provided with a functionality. जहां पे आपके stairs की एक functionality, they are auto moving, there are mechanisms involved, जहां पे motors involved है, जहां पे आप ऐसी चीजें create करते हैं, उसे आप utility patent के अंदर categorize करेंगे. See, if anywhere I'm not able, you're not able to understand my language or something, please also do put it in the chat box. Swapnil will be keeping me informed of the same. Okay, so I hope utility and design is clear. where जहां पे आप उसका सिर्फ लुक एंड फील जिससे आप एडवांटेज अचीव कर रहे हैं तो आप उसे डिजाइन पेटेंट में कैटेगराइज करेंगे, पर जहां पे आप उसका वर्किंग फंक्शनैलिटी मेथड, ये चीजें चेंज करते हैं तो आप उसे यूटिलिटी पेटेंट के अंदर कैटेगराइज करेंगे. ओके, सो एज पर इंडियन लॉ व्हाट कैन नॉट बी पेटेंटेड. जब भी हम पेटेंट्स की बात करते हैं, लोग हमसे पूछते हैं कि क्या क्या चीजें पेटेंट होती है. अपार्ट फ्रॉम क्या क्या होती हैं, वी लर्न व्हाट ऑल थिंग्स कैन नॉट बी डन, सो दैट we are quite sure कि okay, these things cannot be done, rest everything can be patented. For example, scientific principle or formulation of an abstract theory. This means अगर आप कोई hypothetical theory की बात कर रहे हैं, like time travel, nobody knows how to do that. We all know it is possible, but we don't know how to do it, then it is not patentable. See, when you decide to file a patent, the things that needs to be clear is what do you want to patent, how do you want to patent, and like how will it function. If these questions are clear to you, then you can file for a patent. Okay, what way it is possible and like how it will be helpful, what is the efficiency that it is improving. If all these questions are clear to you, then you can go ahead with the patent. Scientific principles like law of motion, law of gravity, these things are scientific principles, they exist, you cannot file a patent for it. Okay, discovery of any living non-living things. See, there is a difference between invention and there is a difference between discovery. Something that already existed and you only found it, आपने सिर्फ ढूंढा है, something that is God created. Okay, we can say like that. Something that is already existing and you just found it, that is called a discovery. You can give it your own name if you want, for just to earn a privilege of that you found something, but you cannot call it an invention and file patent on it and restrict others from using it. So that is one thing. Okay, an invention which claims anything obviously contrary to well established natural laws. There are some things that work as per natural laws. That means energy can be converted from one form to another. We know that. We know कि without any input there cannot be any output. ठीक है, इनपुट के बगैर आउटपुट नहीं हो सकता. अगर आप ऐसे कोई थ्योरी के बारे में डिस्कस करते हैं जहां पे नेचुरल लॉज, आप ऐसा कहेंगे कि ऊपर से गिराओगे ना तो जमीन पे पहुंचेगा ही नहीं, that means you're talking the law against gravity. How? If you can prove it, well and good, but if you're just talking hypothetically, then it's just a vague theory and it cannot be patented. Okay, a mere discovery of a new form of substance. There is something that already existed and you just discovered something that is a different form, but उसका कोई efficiency, उसकी working method, methodology में कोई difference नहीं है, तो उसे आप patent नहीं बुला सकते. Okay, this is very important. The next point, that is the mere arrangement or rearrangement or duplication of a known device. See, when we are talking about patent, we would have heard, हमने ऐसा सुना होगा कि दो अलग अलग प्रोडक्ट्स को मर्ज करके अगर हम उसकी क्वालिटीज एक में ला पाए तो हम उसे पेटेंट करा सकते हैं. फॉर एग्जाम्पल, देयर वर व्हील्स, देयर वर शूज, पीपल कंबाइंड इट टू मेक अ स्केट व्हील्स. इट्स एन इनोवेशन, नो डाउट, बट suppose you decide to make design a chair with a bulb. मतलब एक ऐसा चेयर है जिसमें आप एक टॉर्च अटैच कर दिया है, बिकॉज इट्स वेरी डिफिकल्ट टू फाइंड अ टॉर्च व्हेन यू आर सिटिंग ऑन द चेयर. दैट इज नॉट अ पेटेंट, बिकॉज वो पेटेंट नहीं है क्योंकि दोनों प्रोडक्ट की वर्किंग इंडिविजुअल है. अगर चेयर नहीं होता तो भी टॉर्च वर्क करता और टॉर्च नहीं होता तो भी आप चेयर पे बैठ सकते थे. बट you decide to make a self glowing chair. That means आपने मल्टीपल बल्ब्स अटैच कर दिए हैं चेयर पे. अगर कोई बंदा के चेयर पे बैठता है तो वो बल्ब ग्लो होगी, अगर वो बंदा चेयर से उठता है तो बल्ब ग्लो होना बंद हो जाएगी. जैसे ही वो बंदा बैठता है उठता है, वो प्रोसीजर से एक चार्ज जनरेट होता है, एक पावर जनरेट होता है जो आपकी जो लाइट्स हैं उसको ग्लो करने में हेल्प करता है. इफ two products which is combined into one work interrelated, अगर वो एक दूसरे से कंबाइन होके कोई वर्क परफॉर्म कर रहे हैं तो आप उसे पेटेंट फाइल कर सकते हैं. So I hope now it is understood. You cannot merely arrange or rearrange product and say it is patent. You will have to prove that they are interrelated and works together. Then you can file a patent. Okay. A method of agriculture or horticulture. India is an agriculture based country. You cannot say कि आपके पास एक न्यू मेथड ऑफ फार्मिंग है कि आप किस तरीके प्लांट को कितने टाइम में पानी देके आप उसे ग्रो कर सकते हो. यू कैन नॉट यूज सच थिंग्स to file a patent. But if you have a machine, a method to help the farmers, like sprinkler methods, drip irrigation, ये सब methods हैं जिसे आप पेटेंट के लिए फाइल कर सकते हो. बट अ प्योर मेथड ऑफ फार्मिंग जिसमें आप नॉर्मली जो मिट्टी है, सीड है, इस पे क्लेम नहीं कर सकते. ओके. एनी प्रोसेस फॉर द मेडिकल, सर्जिकल और डायग्नोस्टिक पर्पसेस, लाइक फार्मिंग, अगर किसी को ट्रीट करने का कोई मेथड है, किसी को डायग्नोस करने का कोई मेथड है, तो आप उस पे पेटेंट फाइल नहीं कर सकते. ठीक है. प्लांट एंड एनिमल इन अ होल, अगर आप कोई प्लांट डिस्कवर करते हैं, एनिमल डिस्कवर करते हैं, उस पे आप पेटेंट फाइल नहीं कर सकते until and unless you have made biological modification into it. This is one of the very important points. Again, a mathematical or business method or a computer software as an algorithm. इंडिया में अगर कोई बिजनेस आइडिया है आपके पास, लाइक Amazon, ऑनलाइन सेलिंग के मेथड्स, फूड सेलिंग ऑनलाइन, ये सब एक बिजनेस आइडियाज हैं जो इंडिया में पेटेंट नहीं होते. दैट इज द रीजन देयर वाज Amazon and Flipkart existed, there was Airbnb and Oyo existed. So all those things can be, easily done in India. You cannot patent such concepts in India. Mathematical formulations not possible. प्योर कंप्यूटर सॉफ्टवेयर पेटेंट नहीं होते इंडिया में, वो चीजें कॉपीराइट के अंडर सिक्योर होती है. एंड इन्वेंशन विच इज इफेक्ट इज ट्रेडिशनल नॉलेज. दैट मीन्स कोई चीज है जो आपके एंसेस्टर्स को पता थी, you got the knowledge of it, you cannot file a patent on such concepts. Okay. World में, in the world, 90% of patent is filed on improvements. See, when we talk about patents, usually people are scared because it is very difficult to find something that is innovative or novel and 100% unique. Nobody is asking for a 100% unique product. What is expected is 1% modification in the existing product. अगर आप एक प्रोडक्ट को देखते हो, आप कई टूल्स यूज करते हो, कई मेथड्स यूज करते होंगे. If you're looking into something like that and you find that they are inefficient, they are not capable to fulfill the purpose, then the 1% modifications that you do can be filed under patent. Let's take example to understand. There were gramophones. Then came the time of tape recorders, cassette players, Walkman, iPods. All these instruments are used to listen to music. But somebody thought that if I want to walk and listen to music, or maybe it should be me, I only want to listen to music myself. So what should I do? So somebody came of Walkman, which you can move and listen to music. Then came the time of headphones, where you can just listen to your music in solitary. You don't want others to get disturbed, you can do that. Every concept that has been modified has been filed for patent. The mobile phones that you use, first you used to go to STD PC, used to call, the people in the 90s used to. Then there came a time of landlines, cordless mobile phones, and the mobile phones has revolutionized since the time of that Nokia 3110, right? So everyone now carries a smartphone with multiple features. Everything that has been modified, improved, has been filed for patent. This is a very good example of how and when can a patent actually get its credibility. हमसे लोग हमेशा पूछते हैं कि how do you know that my patent will get a value, or when will my patent get a value? See, that is a question. It will take time, because when you're inventing something new, you are putting in front of a market a product that nobody has ever thought about. You are the one person on the entire earth who has thought about something like that. So it will take time for people to accept and to come up with a solution or a place to use it. Like, for example, Spencer Silver was a chemical engineer, and he was developing a strong glue in the year 1968. जिससे वो किसी भी चीज को चिपका सके. He wanted to make a glue of such kind. When in 1970 he completed his work and started testing, he came to know that उसके गम से, उसके ग्लू से कोई चीज चिपक नहीं रही थी. He couldn't stick anything using the glue. He was actually upset about it, but instead of a strong glue, he made a weak glue. So he was very upset about it. So what he did was, because he was an engineer at heart, he still filed for a patent for the composition he had made. In the year 1974, he was visiting a colleague, Arthur Fry. Now, Arthur is a very interesting person. What he was doing is he used to write notes for every book he read, and he was staplering it with using a stapler. He was attaching the notes to every back of every book, the back of the page. Now, when Spencer saw this, he was quite curious to ask that what Arthur was doing. So Arthur was like, look, people take my book to read and then they lose the notes when it is, not attached to the book. So instead of that, I decided to permanently stick it. So Spencer was like, don't you think it is spoiling the book? Arthur is like, I don't have a better solution. If you have, you bring it. Spencer was like, maybe I have something, but it's an experiment. I don't guarantee your book. He was like, fine, let's try. We are scientists. We can take a book. Spencer went to his lab and got the glue, which he had invented 4 years back. He used the glue to stick the notes to the last page of the book. Okay, he closed the book, and when he opened, page did not fall. Now, Spencer was a bit curious to see what the effect was. When he pulled the notes out of the book, it came very smoothly without damaging the pages. That was the first time these two geniuses came up with the concept called sticky notes. We all have been using that yellow sticky notes since ages, and we are still using it. It was the invention by these two scientists, and the glue is still being used. They launched the product with the brand name Post-it, and it is still an active brand name. You can buy this product in DMart if you want. Go and buy it. Okay, so imagine a product which had no value for 4 years, and after that it is still date $1 billion business. So that is the power of trademark and patents and copyrights. If you have something, rights over something, you can take the credibility out of it, and patent may take time, but once it gives the actual value, then nobody can stop you from earning money out of it. Okay. When we are talking about huge things, every small things in the market is also patented. Like for example, in the year 2002, a person in USA patented a method of swinging. उसने कहा कि हम usually 90-degree angle पे झूला झूलते हैं, and it is not that fun. I have a method, a process using which you can swing in 45-degree angle and it is more fun. It is an approved, granted patent because that method of swinging was not proposed by anybody else. So you see how a patent is important, and any small thing which is innovative can be filed for patent. यहाँ पे सिर्फ 6 चूहों को पकड़ने के जो डब्बे होते हैं ना, the boxes which you have seen, the aluminum boxes, instead of that, people have beautifully designed boxes just to catch mice, and it is design patented. Okay. So here is an example of utility patent and design patent. Just make you understand that if you decide to make an instrument, a structure or something, you can either file a utility or a design or both. Like here, Apple, I think the next example is better. So Apple, you all have been talking and listening about foldable phones, mobile phones, right? Now, Apple said that the concept of foldable phone is with a company called LG for the foldable screens, right? Now, what happened was Apple said that if you buy a phone, you're definitely going to buy a phone cover to protect your phone. Now, if you use the normal phone covers and you use the bending phone, the cover will bulge out from the side. It will look so pathetic because it is not an adjustable phone cover. Although the phone has started bending, the covers are still not made to bend. So they have designed a self-adjusting phone cover which can stretch and fold as per the movement of the phone. Now imagine there may be 100 pieces of phone sold, but there are more than 2,000 pieces of covers sold because we can keep on changing the phone covers. We don't keep on changing the mobile phones that frequently. So they came up with a bigger business because there are multiple companies who are making phones, but now they only own the rights to sell them foldable phone covers. So you see, innovation can be made in any sector. You just need a different perspective to think. And the phone covers which they designed for their own Apple phones was was patented, designed patented by them for their sole products. Okay. Talking about design patents, this is required that we discuss. The needle, जो सुई आप देखते हो, the design change revolutionized the entire industry. First, people used to hand stitch. They had to put the needle in the the thread in the eye of the needle, and it was at the top corner. When the eye of the needle went from top corner to the bottom corner, the entire stitching industries changed, because there were invented the stitching machines, which was used for stitching purposes to make the work easier. Every different clothing like cotton, leather, denims were stitched using different types of needles, obviously based on the cloth type. Every needle that was designed for different type of clothing has been applied for design patent. You can see it on the wall. So you see, everything, every small thing that you touch is patented. The toothbrush that you use, everything that you see, the mobile phones, the applications, the safety pins that you use, everything is being patented, and you touch, that is patented. So every product, every designs that you make can also be filed under patents. Okay, a normal Apple phone has more than 200 patents filed. The design of the phone, the design of the screen, the design of the screw, everything that you touch in a mobile phone of Apple is patented. That is why they are expensive. They are not just expensive because they are a huge brand. They are expensive because they are proprietary work. Okay. So we'll see a few more examples which are in your field and done by mega giant companies. Okay, so Buckminster Fuller, we all have learned about him. He patented and protected the geodesic dome. The Buckminster Fuller is a shape of has a geodesic dome-like structure, and that structure is design patented by him. Okay. Now, in the year 1889, the first skyscraper, the building that was made, was design patent protected by Buffington. Apple has a design patent for its Fifth Avenue store. That means the store which they made has the architectural design is design protected by Apple. Okay, Frank Lloyd patented for prismatic glass tiles. The glass tiles which they designed was design patented by Frank Lloyd. Apple has another design patent for circular stairways. How many design structures have you designed and you're thinking of designing? Such small things can be design patented. The tiles, the flower pots, everything that you touch can be design patented. A Calatrava designed for his turning torso building. Just imagine, even the turning doors, the knobs, the clips, everything that you design can be patented, can be copyrighted, and if it's an architectural structure which provide a public attention, which reaches to public, it gives you a public revenue, can be even trademarked because it has they are a brand in themselves. Like we saw the example of Taj. Right. So all these things can be design patented, and you as an architectural student, faculty, or maybe a PhD candidate, you can actually pursue patent and uplift your profile. So these are few benefits that you can enjoy if you have a patent in your portfolio. Talking about patent, you don't need an actual architectural structure, an actual product or a prototype. You just need everything on a paper. प्रोटोटाइप की जरूरत नहीं है. आपके पास अगर complete theoretical description है about your content, you can file for a patent. Like for example, so these are the benefits that you can enjoy if you have a patent. International recognition. See, I told you, when you file a patent, you are the sole owner of the concept in the entire world. That means only there can be one idea can be made once, only one time it can be disclosed. So you will be the first person and the sole person who knows about the idea in the entire world. Okay. Second, amplified scholarship offers. If you decide to do your masters or do your further studies or take a job in a big company who makes, and your field is all about innovation. See, engineers can everyone, every other field may have a restriction to because of the technology or because of the knowledge. Your field always talks about innovation because you cannot create or replicate something which somebody else has done. You will actually have to think to make something more beautiful. Maybe it's the design of a bridge, maybe it's a design of a building or any small thing. You will have to design, think out of the box. You are the people with the maximum number of copyrights, design, trademarks, which you are actually just keeping it hold in yourself. You'll actually have to explore, because once you file these things, you are the sole people in the entire world who can actually recreate it. Okay. Funding opportunities, industrial job offerings. If you are unique, see, instead of saying that I have a out of the box mindset or I am innovative perspective, I can design something new, show them with the IPR numbers, show them with patent copyright numbers on your portfolio, which takes around an hour to file, just maximum an hour to file. You can show them that, see, I have patents, I have copyrights, that shows that I am unique mindset, I can think out of the box. People will come back to hire you. People will not wait to give you a scholarship, because you can actually think out of the box. Royalty income. If you have actually generated provided someone with patented work, you can earn royalty till the work exists, like the photograph of Eiffel Tower, as I told you, the photograph of Empire State Buildings, the photograph of Taj Hotel. So imagine what type of credibility you can earn if you have a copyrighted patent or designed work, right? You can be an entrepreneur. You can be a person who can actually claim that every work that I do is copyrighted, so it's all unique. Nobody else can have it, and nobody else has ever made it. So you will be approached first with a new mindset. You get startup recognitions. If you want to get funds as a startup, the only important point they have is you need to have a patent or a copyright or a trademark, and that can be fulfilled using IPR. Okay. If you are a professor, if you are a faculty member, you can see all those benefits which a student or a researchers have, you can definitely have. You can have collaboration with industries, you can actually be a consultant for these industries, you can be an entrepreneur. Apart from that, you may be publishing papers, right? So a patent can give you 50 points in the CAS criterion, but instead of that, a paper gives you only 10 points. So let's have a patent and then file multiple papers on something. So you can have both the benefits parallelly. Okay. As an institute, if your students and faculties have patent, you can score higher in accreditations. See, a good infrastructure, a good faculty, a good student, maybe now that it's very common in all the colleges. But now what can outstand these things is how much IPR activity is going on, how much innovation is going on, how much fund from the government comes to you as a part of IPR program. And these things can actually help you to upgrade the NAC accreditations and to stay where your accreditations has reached. So you can see that every accreditations has different scores for just IPR activities, patent registrations, copyright registrations, which your institute can take benefit of. Okay, so talking about patent valuation, we already discussed so much that even a photograph, an architectural structure can have. Here is an example of two engineers from India who developed a feature on iOS platform, had a patent on it, and due to their luck, Apple company violated their rights by implementing that into their phone without their permission. They were not aware of it, or maybe they did not mind so much. These two engineers claimed against Apple for a damage amount of 5,600 crore. Two Indian engineers sued Apple and are likely to get rupees 5,600 crore in damages. So not if they claimed that amount and Apple had to pay because they had patent over it. So imagine if you have an architectural structure, you have a design, you have a trademark, you have a patent on it, and let somebody else violate it. You just have to draw it on paper and have a rights over it and show it to somebody. Let them make the building, and then you can go and stand in front of them and say, "Look, this was my design patent. You copied it. Now you have to pay me for it." Simple. The amount that you are going to ask from a huge builder will be great to start your own company. So I'm not giving you any hint, but I'm just saying if you have a right, do not give it away for free. If you have some talent, do not give it away for free. Secure it using patents, copyrights, and designs so that nobody else can misuse it without your permission. Okay. Being a part of India, this is your responsibility that you do it, because see, in the ranking sector, you can see India at the 7th level. Yes, ranking 7th in IPR filing. It is nothing to be proud of because of the count. China is ranking first. You can talk about the pandemic, the COVID, and all the copying that is happening there, but still, China has filed 15 lakh 42,000 patents in the last 1 year. In the last 2019, they have filed 15 lakh innovative ideas. US is ranking second with only 5 lakh 97,000 patents. That means from the first and second rank, there is a gap of 10 lakh innovative ideas. The you can say the Cold War type situation, which is between USA and China, is not just because of whatever is happening. It is because there is a patent law which is acting. If China gets active, they are going to rule the world with just their whole source of IPR. India has only 50,000 patent filings in a year. And in that 50,000, 60% patents are filed by another country in India. That means, suppose Amazon decides to file, or Google decides to file, or Samsung decides to file, they are patents by different countries and filed in India, although it shows up in the count of India, but they are not Indian patents. So in that 50,000, I think as an individual, maybe 1% people will be filing. Rest all is company filing. So if you want to stand out, see, there are less job opportunities. Maybe there is a lot of competition. But when we talk about IPR, there is nothing. And if you as an individual want to stand out, the only factor which can show you is IPR. India is still trying to gulp down the culture of IPR filing. You can start the race earlier with more IPR filing, because now you know what IPR is, what is the importance, and how you as an individual can secure your rights by filing IPR. Okay. So I think patent, copyright, and trademark are clear to you. If you have any questions, Swapnil and I will be answering to each and everything. Magic Prince is an established company in Sangli itself. So if you have any doubts, you can even talk to him personally. We have been partners for quite a long time now. And Microwave Consultancy has been serving the students for the past 8 years. So if you have any doubts or queries, you can ask now, or you can contact us on all the information provided online. Thank you.
Thank you, ma'am. Now I'm requesting Sate sir to take over the session, and if anybody has any queries, please feel to ask.
Hello, sir. If any students have any question, you can ask them to ask. They can even unmute and ask us. No problem.
Thank you, Pooja ma'am. Actually, it was a great session. Information was very good, and as far as any creative field, architecture is mother of all arts. So we are on the right platform and at the right time. if you get the information at a beginning itself, it is very useful for the profession itself. And I guess everyone would be interested, and many more patents and copyrights will be registered henceforth from India. I request the students, if you have any kind of doubt or questions, please raise your hands or put it in the chat box. I guess there are no questions raised up till now. But Swapnil is from Sangli itself. You can call him anytime, and I guess Pooja Madam would be guiding you all throughout henceforth if at all you have any kind of difficulty. I request still all the students to ask any question. And one more thing is important as far as PhD students are concerned, or even the thesis students are concerned. When we write the thesis, it is very important that we give the references or the credits to that particular person who has initially written that particular matter, or the whatever research that he has done, or done the paper presentations. So it is very important that one should give the credits to that particular person, and it's high time that we should write and get the credits for the same. So thesis मध्ये अजूनपर्यंत मला असं वाटतं की बऱ्याच वेळेला मुलं इकडून तिकडून काहीतरी आपण नेट वरून घेत असतो, तर बी केअरफुल फॉर दॅट ऑल्सो. Whenever you take references from anything, give credits, and then only you can proceed further, which will be very beneficial. Otherwise, if the awareness among the people has increased, and you can be fined or need to pay a big chunk of amount that you have earned, hard earned. So, Atharva Gosari, you have any questions? Atharva Gosari?
I have dropped my number in the chat box so that
Yes, sir.
people can eat.
तुला काही विचारायचंय का अथर्व?
Sir, no, sir.
हे बोलूया आपण.
So anyways, we are not forcing anybody for any questions, but we are just saying that if you have, do let us know. With like Swapnil sir's number is already dropped in the chat box. Contact him. He's a person from Sangli, so I think he'll be able to address your problems personally. And if you have any further queries, you can even directly contact us. We are no issues. But I think he's from there, so maybe he'll be able to communicate better. No problem with us.
Yeah. So thank you, Pooja ma'am. Thank you, Swapnil. I guess
Thank you, sir.
this particular session will help all the students
Yes, sir.
and architects.
Sure,
Thank
sir.
you so much.
Thank you so much.